Running a business while bankrupt is possible in Australia, but bankruptcy imposes important legal restrictions that every business owner must understand before continuing to trade. One of the biggest misconceptions about bankruptcy is that it prevents you from operating a business altogether. In reality, many bankrupt individuals can continue working or even operate as sole traders, provided they comply with their obligations under the Bankruptcy Act. However, running a business while bankrupt is very different from managing a company, and understanding that distinction is critical. A bankrupt person can generally continue operating as a sole trader or even start a new sole trader business. Business income remains assessable during bankruptcy and may affect compulsory income contributions payable to the bankruptcy trustee. Trustees may also require access to financial records, bank statements, invoices, tax returns, and other documents to assess income, assets, and compliance with bankruptcy obligations. However, bankruptcy creates significant restrictions when it comes to companies. An undischarged bankrupt is automatically disqualified from acting as a company director or managing a corporation unless the court grants permission. This restriction extends beyond holding a formal title of director. In some circumstances, a bankrupt person who effectively controls or manages a company behind the scenes may be treated as a de facto or shadow director, creating significant legal risks. There are also important obligations when obtaining business credit. If a bankrupt person seeks credit above the prescribed statutory threshold, they must disclose their bankrupt status to the lender. Business assets may also come under scrutiny, and depending on the circumstances, certain assets used in the business may vest in the trustee for the benefit of the creditors, while others may remain protected under the legislation. Another common mistake is assuming that moving assets into a new business structure or transferring them to family members will protect them from bankruptcy. Trustees have broad investigative powers and may review transactions entered into before or during bankruptcy, particularly where assets have been transferred for less than market value or in circumstances that disadvantage other creditors. Non-compliance with bankruptcy obligations can lead to recovery proceedings, penalties, or even an extension of the bankruptcy period. Because the rules governing business activities during bankruptcy are complex and the consequences of getting them wrong can be significant, understanding what you can lawfully do, what restrictions apply, and how to continue trading without breaching your obligations is essential to protecting both your business and your financial future. Contact us today for a free 30-minute consultation with one of our experienced team of insolvency professionals, and let us help you protect your rights.